I have prepared this short video to help explain the legal requirements for marriage in Australia. Any person aged 18 years or older who is not currently married can legally marry. A person who is 16 or 17 years of age can still legally marry, provided certain requirements are met, and that is one party to the marriage is 18 years of age or older. The person who is under 18 years of age must obtain a court order from a judge or magistrate allowing the marriage and must have written consent from their parents before the marriage can take place. It is illegal in Australia to have two people who are both under the age of 18 to marry each other. Under the Marriage Act, the bride and groom must complete the notice of intent to marry a minimum of 1 month and 1 day prior to the wedding taking place. The notice of intent to marry will remain current for 18 months from the date of lodgement with me. You will find a link below on this page of my website where you can download the notice of intended marriage, or I can post this form to you. All you have to do is print it off, fill it out as much as possible in black ink, and bring it along with you when we first meet. Of course, I can always assist you with the completion of this form. Legislation provides that under certain circumstances, couples may request a shortening of 31 days' notice by applying to the relevant authority for consideration. If you require more information about shortening the 31 days period, please contact me for further details. Where one party to the marriage is overseas or interstate and cannot sign the notice of intended marriage, then the notice of intended marriage can be lodged in one name only. The remaining party must sign the notice of intended marriage as soon as practical before the wedding ceremony can take place. Only original documents can be cited. If you are born in Australia, you are required to provide your birth certificate or an authorised extract. An Australian passport cannot be accepted as a form of ID under any circumstances. If you are born outside of Australia, a birth certificate is still the preferred option. However, I can also accept your current overseas passport in lieu of your birth certificate. If you have been previously married, I will need to cite the original divorce certificate. Or, if your previous partner has passed away, I will need to cite the death certificate. All original documents must be produced before any marriage can proceed. All documents must be presented to me in English, or with an official translation authorised by a legally recognised translator. You are required to have 2 witnesses over the age of 18. It doesn't have to be a male and a female, as long as they are both 18 years of age or older. If this is going to be a problem, I can always organise witnesses for you. If your fiancé is overseas and you're intending to apply for a spouse visa, I have assisted many couples over the years with their proposed marriage confirmation letter and lodgement of their notice of intended marriage. Contact me if you have any questions or wish to discuss this in more detail.